What happens when you remove an attorney-in-fact from a POA? Imagine trusting someone with your most personal decisions and then needing to take that trust back. What do you do when you want to stop someone from acting on your behalf under a power of attorney? Let's explore what happens when you remove an attorney-in-fact from a power of attorney. When you decide to remove an attorney-in-fact, their authority to act for you ends immediately. This means they can no longer make decisions or sign documents in your name. The key step is revoking the power of attorney itself. To do this properly, you need to sign a written notice or a formal revocation document stating that the attorney-in-fact's authority is withdrawn. It's important to send this notice to the person you are removing and to any third parties who relied on the original power of attorney, like banks or healthcare providers. If the power of attorney was recorded, especially for real estate transactions, you should also file the revocation with the appropriate government office. This helps prevent the old power of attorney from being used again. Once the revocation is in place, any actions taken by the attorney-in-fact after that point are considered unauthorized and can be challenged or ignored. It's worth noting that actions taken by the attorney-in-fact before removal are usually valid if they were done in good faith. But any actions after revocation are not authorized and should be addressed quickly. Notifying all relevant institutions is essential to prevent any unauthorized transactions or decisions. People often remove an attorney-in-fact because of misconduct, such as misuse of funds, or because they no longer trust the person. Sometimes, it's due to a change in the relationship, like a divorce or falling out. If the principal is unable to revoke the power of attorney because they are incapacitated, then a court must step in. Family members or interested parties can petition the court to remove the attorney-in-fact if there is evidence of abuse or neglect. The court might appoint a guardian or conservator to handle the person's affairs instead. If the original power of attorney document names a successor or alternate agent, that person automatically takes over once the first attorney-in-fact is removed. If no successor is named, then the court or the principal, if capable, must appoint a new agent or guardian to fill the gap. Removing an attorney-in-fact is a serious step, often taken to protect vulnerable elders from harm. Acting quickly and properly documenting your concerns can help prevent abuse. Consulting an elder law attorney can ensure the revocation is done correctly and your loved one's rights are protected. In the end, revoking a power of attorney ends the attorney-in-fact's authority immediately, but it must be done carefully, with clear communication to all involved parties. This process helps keep your decisions in your hands and safeguards your interests.